Hi, I'm Travis Walker with the Law Office of Travis R. Walker. The state of Florida, as of July 1st, created a monumental change to the alimony law here in Florida and wanted to provide a brief overview of how that's working. Short-term, mid-term, and long-term marriages are now specifically defined at 0 to 10, 10 to 20, 20 and above, respectively. So that's a big determination. Usually, before it was up to 7 to 14, and then over 14. So now the length of the marriages have been extended, which is important because then you have the question with regards to alimony. Alimony becomes, durational alimony becomes a question and a percentage or a maximum percentage of the length of the marriage. So for a short-term marriage, it's up to 50%. For middle-term marriages, it goes up to 60%. For long-term marriages, it's up to 75% of the length of the marriage. So if you have a 20-year marriage or a 30-year marriage, that can only go up to 75%. Then you only have about 22 and a half years of potential alimony for a 30-year marriage, as opposed to previously, it could be a permanent alimony, and you could be looking at 30, 40, 50 years, who knows? And then you have to go through the modification process to determine what's going on there. Also, durational alimony may not happen anymore for marriages of less than 3 years. So just completely forget the idea that if you have a short-term marriage, even if there's this huge difference in income, that 3-year marriage is going to provide you, or you're going to have to be paying alimony. So that was a huge difference maker when it comes to alimony at that point. Also, there has to be written findings now of the necessity for a life insurance policy. Usually life insurance policies were part of the deal, to ensure the alimony payments that were coming later on. And that's a big part of it. But permanent alimony is now eliminated. It is not retroactive. So if you had an alimony that you started paying back in 2020, that does not mean you are now off the hook. It's moving forward. It is prospective, not retroactive. That being said, of course, for old alimonies, you can modify the alimony if there's been a substantial change in circumstances, but you will be falling under the old law. Of course, anytime there's a new law change, it will impact the way the judges are seeing the law. So be mindful of that, is that even though you're using the old law, the effects of the new law may go into the calculations as to what the judges are thinking, and that's a big part of the process. So if you have any questions regarding alimony, the new alimony law, give us a call here at the offices of Travis R. Walker. Love to see if it's something we can help you out with.